A very warm welcome to all. This is Harish Kumar from NSDL. Today, I would like to take you through the key developments that have transpired on transmission of securities. Before we dwell on the key developments that have transpired in transmission of securities, it's very important to understand what transmission of securities in simple parlance means. Transmission of securities basically is devolution of title. Devolution in simple words means transfer of title in case of death of the account holder or the individual, what we call. In case of a corporate, it could be the bankruptcy or winding up. So the devolution of title in those cases of corporates would happen only in case of bankruptcy or winding up. Let's look at the scenario in for transmission of securities to whom the title would flow. In case of a joint account, the securities would get transmitted to the surviving holder. In case the nomination facility is availed by the account holder, then in such cases, the securities would get transmitted to the nominee. In case there is a will which is left by the deceased and he is appointed an executor for that matter, in such cases, the securities will flow to the executor. In none of these scenarios, if there is a legal heir, then the securities would get transmitted to the legal heir. If there is a letter of administration which is likely to be obtained by the legal heirs or the claimants as such for that matter, then the securities would go to the administrator. If there is a succession certificate which is obtained by the legal heirs, then these shares would move on to the successors, to the estate. So this basically is the flow of transmission of securities in case of death of the account holder. Now let's look at the key developments which have transpired pursuant to SEBI LODR regulation amendment and the SEBI circular dated May 18th, wherein the documentation for transmission of securities were completely simplified. In fact, SEBI has gone to the extent of prescribing the formats for the transmission of transmission request forms. Then you can say affidavit, indemnity bond, no objection certificate which is required to be submitted or furnished by the legal heirs or claimants for processing the transmission request. The first and foremost key development which has actually happened in the SEBI circular is enhancement of the value. Now the value earlier, if you all recollect, was 5 lakhs. The monetary limit has been enhanced now to 15 lakhs. Legal heirship certificate or equivalent certificate, you can call it survivor heir certificate, is which is a document issued by a competent authority. The Tahsildar or the executive magistrate usually issues these kind of certificates, is one of the document which has been given sanctity by SEBI circular, and it is acceptable as one of the documents for transmission. Acceptability of will is also one of the document which can be accepted for transmission of securities. There are, as I said, there are prescribed formats for indemnity affidavit, then no objection certificate, which is required to be submitted by the legal heirs or the claimants. What additional development which has happened is for the Demat, usually the documentation process was separate. For the physical, the documentation was separate. But SEBI has, with this circular of, by simplifying the documentation for transmission, has made it similar documents for both physical and Demat securities. SEBI has given sanctity to the will. In case of will, the unregistered will also can be acceptable as one of the document. But the only condition is the will has to be insisted to be probated only in terms of the Indian Succession Act. That is, in case of no, probate of will is mandatory, where if it is the will is within the presidency towns of Madras, then Calcutta, then Mumbai. Only for these territories, the you can say the probation of will is mandatory. The rest of the territories like Bangalore, Delhi, and other places, the will is made optional. So even attested by the legal heir. So there's an additional development which has happened with, or the change which has happened. So usually the earlier scenario used to happen. The copy of will was submitted by the legal heirs. So now the will can be submitted, but that needs to be attested by the legal heirs. and this is a sufficient evidence for the depository participant to take on record, and it will also assist them to identify the legal heirs who are claiming these securities. So this is an additional development which has transpired with the SEBI circular of May 18, 2022. As I said, the key developments which have happened is also reflected in the NSDL business rule. So the NSDL business rule, which is amended, is the business rule 12.6.2, which pertains to transmission of securities held in a single account without nomination. There is another business rule which is amended, which pertains to 12.6.3.7, which relates to nomination of securities. And in addition to this, the earlier requirement was whenever the DP is notified on the death of the account holder, the freezing of the Demat account was captured by the DP to ensure that securities do not move until the documents are received from the legal heirs or the claimants, as the case may be. So this provision has been made uniform across all in case of surviving holders, in case of single account, in case where the nomination facility is availed. So the freezing part is something which is a new development which is also captured in our NSDL business rule. Now let's look at the documentation for transmission of securities in case where there's a nominee who is appointed by the account holder, and on death of the single holder, or in case there is a joint account, then on death of all the joint holders, then the documents which are required to be submitted by nominee are mentioned. The first and foremost document would be the transmission request form, which is required to be signed by all the nominees. The new requirement which has happened with the SEBI circular is the second part. If you can see, the death certificate, earlier requirement was only the original death certificate or a notary attested copy was submitted, but now there is a slight change. The copy of the death certificate, which is required to be attested by the nominees, and it will be verified with the original by the DP and taken on record. So this is a slight change which has actually happened with this SEBI circular. And there is an additional development. Self-attested copy of the PAN card, what we call, of the nominees is required to be submitted by the nominees to the DP for processing the transmission request. This is a mandatory requirement. And if apart from this, the copy of the client master list, if the Demat account is not held with the same participant, is required to be submitted. This is an old requirement, so this requirement continues as such. Now let's look at the scenario where transmission of securities is to be made to the legal heir, where the nomination facility is not availed, and the value of securities is up to 15 lakhs. And in case of death of the single holder, or in case of death of all the joint holders, the documentation which is required to be submitted by the legal heir to claim the transmission. First and foremost document is the transmission request form, which is required to be submitted by the legal heirs and claimants. The next requirement would be the original death certificate or copy of death certificate attested by the legal heirs or claimants, which is verified by the DP along with the original. And the self-attested copy of PAN card also is required to be submitted by the legal heir, which is issued by the income tax department. In case the legal heirs do not have the Demat account with the same participant, then the client master list of the legal heirs would also be required to be submitted. Apart from this, the legal heir also has an option of submitting a succession certificate or probate of will, or you can say letter of administration or a court decree. The additional document which has been given sanctity by SEBI circular is the legal heirship certificate or its equivalent certificate issued by the competent authority, that is the Tahsildar or the executive magistrate, we call it in common parlance. So this document also could be could be submitted. Any of these documents. It's not necessary that succession certificate has to be submitted and probate and letter of administration. So these are all optional documents. One of them could be submitted, and along with this, the legal heir needs to submit notarized affidavit and indemnity bond, and also the NOC, which is required to be submitted. Now let's look at a typical scenario where transmission of securities is made in favor of the legal heir, where the nomination facility is not availed and the value of securities exceeds 15 lakhs. This is also an event in case of death of the account holder. If it is a single holder, or in case of joint account, then after the death of all the joint holders, then the documents which are required to be submitted by the legal heir to claim. The earlier scenario, we were talking about less than 15 lakhs. Now, the documents which is required to be submitted by legal heir for value more than 15 lakhs. We are focusing on this slide basically. The transmission request form is a fundamental first document which is required to be submitted. The death certificate, the original death certificate or copy of death certificate which is attested by the legal heirs or claimants, which is verified with the original, is another document which is mandatory document required to be submitted by legal heir. Self-attested copy of the PAN card of all the legal heirs issued by the income tax department is required to be submitted. In case the legal heir does not have a Demat account with the participant, then he or she needs to submit the copy of the client master report. In addition to documents which were mentioned, these are all the optional documents, that is the succession certificate or probate of will, or you can say letter of administration issued by the court or a court decree. Even legal heirship certificate is given sanctity. So for value exceeding more than 15 lakhs, this is also another document which can be submitted along with a notarized affidavit, indemnity, and no objection certificate from all the legal heirs to claim the transmission. Now let's look at the situation where there is a transmission of securities in case of Karta. You're all aware, in case of HUF, the Demat account is opened in the name of the Karta, and in case of the death of the Karta, the surviving members are under an obligation to appoint eldest surviving member as a new Karta of the HUF. So once the appointment of the new Karta is completed, then the surviving members are under an obligation to approach the DP to facilitate the change of name of Karta in the account of the HUF, so that they can continue with the existing HUF. In place of the deceased Karta, there would be a new Karta, and the surviving members will make a joint application to the DP, and the DP, after appropriate verification of the documents, can facilitate the change. The transmission, but in case of Karta, the discretion of continuing with the HUF or dissolving or separating or partition is something which is the discretion of the you can say the family members or of the HUF. So in case the HUF wants to separate or partition and the surviving members intend to claim those securities, then in such cases the HUF account needs to be closed, and the securities which are there in that existing account needs to be transmitted to the individual members of the HUF, and the Demat account of the Karta can be closed. Now let's look at the documentation which is required to be submitted to facilitate change of Karta. In case of death of the Karta, the original or copy of the death certificate of the deceased Karta, which is attested by the surviving members, which is subject to verification with the original, is required to be submitted, or a copy of the death certificate attested by the notary public or a gazetted officer. In addition to this, a copy of the PAN card, proof of identity and proof of address, and photograph and KYC of the new Karta along is also required to be submitted. On submission of these documents, the DP will capture the original ink signed specimen signature in the system, along with the list of the declaration which is submitted by the HUF surviving members in the prescribed form, providing their consent for appointing the new Karta and which also captures the name of the the date of birth, gender, and relationship with the karta of all the surviving members. So if the still in case the existing HUF does not intend to continue, in such cases the securities can be transmitted to the surviving members, which results in total partition, and the demat account of the deceased demat account of the deceased, which is opened in the name of the karta, can be closed. Now let's look at the obligation of participant. DP is under an obligation basically on being notified or becoming aware of the death of the account holder to capture, or you can say they freeze the demat account of the deceased, to ensure that securities do not move to the any other account until and unless the transmission formalities are completed. This will ensure that receipt of the documents, that DP is under an obligation to verify the documents which is submitted by the legal heirs, and after being satisfied with the documents, transfer the securities to the appropriate target account. Thank you very much.